Now let's move on to Article 15. This is one of the most important and most controversial articles of our Constitution. Prohibition of discrimination on certain grounds. The first provision of Article 15 provides that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, or place of birth. Let's understand this step by step. What is discrimination? Discrimination simply means treating two people differently, one adversely and the other favorably. Discrimination becomes a problem when it is done based on someone's religion, race, caste, sex, or place of birth. So who shall not discriminate? It is the state that shall not discriminate. So whether someone is a Hindu or a Muslim, white or black, Brahmin or a scheduled tribe, male or a female, whether that person was born in Kutch or Kohima, the state must treat them alike. All citizens are equal in the eyes of the state. Now notice the word only. It means that discrimination can be done by the state on grounds other than the ones mentioned. So if you score well in prelims and get qualified for mains, but your friend scores less and doesn't qualify for mains, then this discrimination is allowed as it is based on the grounds of merit. The second provision of Article 15 says that no citizen shall be denied access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing ghats, road and places of public resort maintained wholly or partly by state funds or dedicated to the use of general public. The grounds are same as the first provision: religion, race, caste, sex, or place of birth. However, there is one point worth noting. This provision prohibits discrimination both by the state and private individuals, while the first provision prohibits discrimination only by the state. So discriminating adversely based on the above grounds is wrong, but the state should also work on bridging the gap that has been created due to historical injustices. For example, men and women should be ideally treated equally, but position of women in society is still lower than that of men. So the state must take some additional measures to advance their position, a positive discrimination in favor of women. This is also known as affirmative action. Keeping this ideal in mind, there are some exceptions to the rule of non-discrimination. State is permitted to make special provisions for some classes of citizens. First, women and children. According to Article 15(3), the state is permitted to make any special provision for women and children. For example, reservation of seats for women in local bodies or provision of free education for children. Second, socially and educationally backward classes, scheduled castes and scheduled tribes. According to Article 15 Clause 4, the state is permitted to make any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. Using this clause, the state is empowered to provide reservation of seats or fee concessions in public educational institutions. Using Article 15 Clause 5, the government can provide for reservation in private educational institutions. However, this clause is not applicable to minority educational institutions, which are separately protected by Article 30. This provision was added by the 93rd Amendment Act of 2005. Third, economically weaker sections. This includes citizens other than those mentioned in the 4th and the 5th clause who are economically weaker. Using Article 15 Clause 6, reservation of seats for the EWS students is possible both in public and private educational institutions, except the minority institutions. This provision was added by the 103rd Amendment Act of 2019.